Hi guys, it's Kathy. I got my intro. I have my regular one too. But while I was getting finding my regular one, I found that. So I thought throwback would be in order today, even though nothing today is a YouTube judge at all. And all of those were YouTube judges, which is why I changed it because it was a lie. It's just a lie. Clickbait. I bet it was clickbait because I had Judge Manning on there. We're going to this judge. We've shown her before. I've shown her before. Not often. She doesn't stream often. She streams way more often than I show her. I'm not saying that, it's her fault. It's my fault I haven't shown her more. But she just doesn't take anything from anybody. If she tells you, if you do A, I'm going to do B, guess what she does? If you do A, she does B. She doesn't even have to think about it. She doesn't have to decide. She doesn't have to have a hearing on it. Probation revocation hearings are real short for her. She doesn't need a hearing on it. She told you. This is it. If you do A, you get B. No thinking involved. I didn't do Dutch Kathy. I just didn't. I don't know how to make only your TV translate me into Dutch. That would be cool if I had that ability. Yes. Yes. Anyway, I'm scared. Here we go. I'm scared nothing is there. That looks right.
I was willing to submit to even hair follicle tests, but it is what it is, and it's done with anyways. But as far as...
Guys, this guy is going to drive you crazy. Wait, the lawyer speaks in the middle, and that's boring. But once she starts speaking to him, he's going to drive you insane. And you don't have far to go.
As the future goes, I have a child that's about to be born in a month, and it's not really about me. It's about the duty that I have been called to do, and it's the assistance that's needed of mine. And I'm not. There's a lot of over the past couple of years, there's been a major change in my perspectives, and I'm glad that I'm able to recognize that the world is about serving others and being of service, and that's all I wish to do. I just wanted the opportunity to be there when the child is born and to be committed to doing so. That's really the only thing that's really important at this goal right now. I have some affairs in order as far as employment, these kind of things. I don't care in what fashion. It's just important that I be there because she really needs my assistance with the other two children as well, which are not mine. But yeah, I just look forward to the opportunity to finally be able to be on a straight track to be of service to not only this family but eventually the rest of society. And as I've wasted many years in my youth, and I look forward to some redemption that everyone else deserves, as me being in service to do so. But other than that, I'm still grateful for the time that I've had here. I've used it to gain a lot of perspective, read a lot of things, and figure out introspection and figure out why things have played out the way they have, and realize that how to go about changing those in a manner that's that can be sustained. And I believe that I've done so, but I'd be willing to do whatever it takes to prove that, and that's all I have to say for now. Thank you.
Thank you. Mr. Crawford?
Thank you, Your Honor. Your Honor, I would like to point out to the court,
It's lawyer time, so just breathe through it. He's coming back. We're going to hear from him much more.
in regards to the credit time memorandum and having reviewed and gone through that, he had done all of his time in connection with the Indiana Department of Correction time, and he was serving time on Elkhart County Community Corrections, or about to start serving that time before the situation had transpired. As of now, towards that sentence of probation and community corrections, which was 2 years and 360 days, he has served 252 days at this point in time. If the court simply considered the violation of community corrections and allowed him to continue on with his status of the current probation time, which was 1 year and 180 days, and then violated him on community correction, he would only have 20 days left to do in connection with that before he would start over the commencement of the other case. The 20 days is somewhat consistent in regards to his significant other having an expectancy of their child on 9/25/2025. So essentially, he's been in custody for 9 months. They did have time together before before the situation had transpired. Thus is why she's pregnant 9 months at this point in time. So I think that does a lot. That has a lot of reflection in regards to this as well too. I note that the court has received a copy of the letter that was filed for Ms. Oliver. She is the mother of a 13-year-old and 11-year-old, and obviously now a soon-to-be-born child as well too. That is Mr. Eiler's child as well. So obviously he is going to have responsibility associated with that as well in the event that the court decides to impose some of the time in connection with probation timelines to be. We're asking the court to consider Elkhart County Community Corrections. He's already still been accepted, and in fact, I did.
Brushing up against the microphone like that, guys, that is way less annoying than what's about to come up. Way less.
Have notification early on in the case, ultimately before we set it for hearing and we went through that process, that he's still an acceptable candidate into their program, and they would take him at whatever level the court deemed appropriate, or was deemed appropriate under the circumstances, I believe. And I do think, Your Honor, it is important. He does have responsibility at this point in time. He is going to have responsibility, even further responsibility at this point. We did talk about various job opportunities he has. One of them is in construction, and the other one is he's aware of a supervisor at Bull Moose where he could find employment there as well too in Elkhart. So he would be able to take on the responsibilities that he will have coming up and will be going in the future. I would note that he and Alicia were together for 2 years prior to his original incarceration in this case. So he had been a big part of the lives of the 13-year-old and 11-year-old. Certainly we are aware of the circumstances that had transpired that led to the events. It really wasn't him, but in terms of the events that transpired in connection originally with this case, and I think he's worked through some of those while at the Department of Correction, and certainly somebody that's willing to work through those on a regular basis, not only any substance issues. Obviously, he did maintain that he didn't willfully consume the marijuana, that the court had made a determination that he had violated in this case, but obviously he's certainly well aware and willing to do anything necessary to address that issue. As the court has noted from time to time in connection, there are things at the jail as well too. He's refrained from any use while he's been here. Instead, he's focused on spirituality and his religion, and I think that is mentioned in some of the letter that his significant other presented as well too. But that is certainly the goal and the direction that he intends to proceed at this point in time. We are asking that you consider simply imposing the additional 20 days and place him on probation then, or in the alternative, if the court deems that that's inappropriate, for a portion of the probated time to be served on community corrections at a level to be determined where he could work himself off in that situation, but certainly be there financially for his significant other and helping her out at least at a minimum in that regard if the court is not inclined to allow him to go out immediately. But again, he understands and he knows that he's got to get this done, and he wants to get this done, and he has an important relationship that is still important that he wants to move through and still be a part of, and we're asking you to give consideration to what has been suggested. Thank you.
Thank you. Ms. Campoli?
Your Honor, we agree with BCCC's recommendation for incarceration. In looking at his history, he has a lengthy criminal history. He was placed on zero tolerance for this sentence, likely because of what was contained in the PSI. He's violated terms previously. He was high risk to defend at the time that we sentenced him. It looks like at the time of the offense, the underlying offense, he was under the influence of fentanyl, and now we have a violation for THC. So the state has concerns that he's not doing what he needs to be doing, and the only other option at this point is incarceration.
Anything further?
In regards to the other situation, Your Honor, I don't think we ever had the lab tests back in regards to the fentanyl as it related to that. There were some issues, certainly.
He admitted it in the last hearing. It's fine. There didn't need to be any tests. She gave him probation with 0 tolerance. That's what she gave him.
In regards to circumstances that transpired in that case, but I don't know if the results ever came back as anything in the system for fentanyl at the point of original situation. I certainly don't want to downplay what had transpired in connection with that case, because that is what it is, and it certainly wasn't. We're not doing that. But in regards to that particular substance, I don't think we ever had any results back on that. But all I would just simply ask is, Your Honor, in light of the circumstances and how and about the a little less than about 18 months or so still left, that the court consider alternative placement. Thank you.
All right. Mr. Ollier, the thing that concerns me is that the original charges that you were sentenced on were residential entry, battery with moderate bodily injury, battery by bodily waste on a public safety officer.
Mhm.
So, and then now we have a community corrections violation. And it was relatively soon after your release. So,
Same day, Your Honor.
I didn't, yeah, it was.
that's what I was just looking at. So, if I put you on community corrections for your probation time, what assurances do I have that you're gonna not come back?
Sorry, not sorry. But I just, assurances? Well,
Yeah.
I mean, I don't know what kind of foretelling, surety necessarily as far as a guarantee. I mean, aside from me telling you verbally, I mean, really, I sincerely am dedicated to not living for myself. And yes, I do admit that the initial offense, however it may have transpired, it was horrible. I feel bad about it. I wasn't really coherent at the time. And
Because you were on some type of substance.
He won't say
So.
that.
it was something, yes.
Mm-hmm.
I wouldn't say it was we don't even have to go into that. It wasn't necessarily.
Well, if you weren't acting of your own accord, then there was something that was making you not act of your own accord. So.
The devil made me do it.
Yes, I will agree. I was not in the right frame of mind. That was in December 23. But honestly, that was the last time that I haven't compromised. All I can say is that if I would have had a retest or.
Her name is not Teresa Caputo because that is a psychic medium. But it's something like that. I just don't know what it is. I can see it. I can see her in the playlist. But it's not on the screen either. It's something like Teresa Caputo, but that's not quite it. She's from Indiana. She covers Michiana and Elkhart, Indiana. And you can only see her here. And she is so good. We're going to see 3 of her cases today. 3. This is the longest by far because of this guy's mouth. On and on. On and on, on and on. Whoops.
Something, it would have most likely tested negative. This was I went straight to community corrections, and well, I took the.
All right, you're not telling me about any assurances. You're just rehashing what I already know.
Oh yes, this is true.
So.
Well, yeah, I'm sorry. I don't mean to get on a tangent there. Yes. Yes, it's not about me, Your Honor. It's really not about me. It has nothing to do with me. If it was just me, then let it be as it should be, and it will be anyways. But it's really not about me. I really am dedicated and looking forward to the opportunity to being of service to the family for once. I've done a poor job in the first half of my life, and I have a good support system there. I really do. My significant other, she looks forward to being engaged and married in the near future. We have this child, although somewhat unexpected. I look for the opportunity to as an opportunity for redemption and to have purpose in my life for once, and do it the right way, as I have failed in prior instances and times in my life. And I just
Okay, so what is your plan to do better? That's what I'm looking for.
my
Like,
plan?
yeah.
Well, my plan. Well, I do have some leads on employment.
Okay, we already talked about that.
Yes.
So you're going to be employed. What else are you going to do?
That's the first. That's the first step.
Okay.
As it's necessary. Well,
Well, it's obvious you don't have a plan, so we're going to go with my plan. So, because you don't have a plan. That's if you don't have a plan, then you can plan to fail, because you have to have a plan in life.
well, I plan to. I mean, I do whatever it takes to stay. Like I said, I have a support system.
Okay, doing whatever it takes is not a plan.
Well, it's more or less like, well, aside from being there for the family, I mean, I would take any steps necessary or where the court deems necessary for maybe apparently substance abuse or whatever it be, because I'm not opposed to anything. I'm not admitting that I never had an issue. I'm saying I don't necessarily right now, but I still take it seriously. I still take it very seriously, and I'm not opposed to any kind of treatment like that. So even if it's community corrections, home detention, where if I'm zero tolerance, and I wouldn't have any dispute if for some reason there was any kind of violation or anything, because I know that I wouldn't compromise. And aside from going home and working, being there for the family, trying to be incorporated in a Unitarian church and those kind of things, aside from whatever you deem necessary to maybe keep me on the right track, for proper guidance, and I would embrace that, and pay the restitution that I owe and anything else to society that I might owe to them, which would be my best effort to not contravene any laws.
Okay, that's fine. All right, so anything else from anybody? All right, the court hereby on the community correction time hereby revokes the defendant's community alternative placement, places him at the Indiana Department of Corrections or Elkhart County Jail, whatever the case may be, for the remainder of that sentence. On the probation time, the court hereby revokes his probation, puts him at Elkhart County Community Corrections. On home detention, zero tolerance. You're to obtain an addictions evaluation, do any follow-up as necessary, obtain gainful and legal employment.
So what that means in shorthand is there are 3 levels. There's prison or jail. Community corrections, where you're locked up at first, but you can earn extra privileges like weekends out, like getting a job, like eventually saving up for your apartment. And then there's probation. He was on probation. So he has to do all of his jail time now. Every day of his jail time. All of it. And then he's back on community correction. No more probation. And it's zero tolerance on community correction. So if he messes that half up, he's jailed the whole way. Or prison. We don't know. Lightfoot, hello.
I will tell you,
Hi.
Mr. Ollier, that when I put you on community corrections, and I word it as such, that it's an alternative placement to the Indiana Department of Corrections. So if you come back on a violation, the only option you have is to go either to the Indiana Department of Corrections or stay here at the Elkhart County Jail, depending on what time you have left on your sentence.
I was muted, wasn't I? Yep, 3 of them. This is the second one. It's much shorter.
There it is. Cause number 2502 F6227, 1805 F5155, and entitled State of Indiana versus Danae A. Tuggle. Ms. Tuggle, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do. Thank you. Please state your full legal name for the record. And ma'am, what was your address prior to being incarcerated, if you recall?
212 Donald.
Your date of birth
430.
and the last 4 digits of your social security number. Ms. Tuggle, my records indicate that we were here on, it looks like August 7, 2025. You offered a plea of guilty pursuant to the terms of a plea agreement. I conditionally accepted your plea and referred your case to the probation department of this court for the preparation of a pre-sentence investigation report. Oh, excuse me, it was a records check. I've had an opportunity to review that. Have you? The records check?
Copy of the records check?
Yes,
Okay, have you reviewed it?
yes.
Okay.
And is there, are there any errors or corrections that you want to point out to the court? Okay. And is there anything you'd like to say on your own behalf in regards to what should happen to you for sentencing on the F5227 or the violation on the F5155?
Nothing with my sentence, and I just would like to just say I'm just ready to get this over with. This has been a long case for me, and I asked to go to prison on my F15, whatever number you said. I asked to go to prison. I've been on house arrest for like 5.5 years, and I'm just ready to get this over with and get this behind me. This case has been very hindering to me, and I'm just ready to start and be new and be done and be productive and, you know, never see you again unless it's Walmart. I don't ever want to see you again. And this case has been like 9 years. It's like literally the longest thing that I've ever had to go through, and it's just hard.
Right.
I'm just ready to be done.
Okay. Great. Mr. Murphy?
Thank you, Your Honor. We do believe that the plea agreement is fair and appropriate. We ask that you sentence her accordingly.
Ms. Campoli?
Your Honor, we do believe the plea agreement is fair and appropriate for Ms. Tuggle. We would ask that you accept it and send it. Thank you.
All right. On the F6227, the court hereby finds the defendant guilty of escape as a level 6 felony. This is a totally stipulated plea agreement, so in accordance with the terms of the plea agreement, the court hereby sentences the defendant to 1 year, 180 days at the Indiana Department of Corrections, executed. There's a $200.
Yep. She's asking to go to prison. She is so sick and tired of house arrest that she wants to go to jail.
Public defender fee in accordance with Indiana Code 353376. And in accordance with the terms of the plea agreement, the state will not file the habitual criminal offender enhancement. On the F5155, the court hereby revokes the community corrections placement, puts her at the Indiana Department of Corrections for the remainder of her sentence. And I wonder if there's a credit. There's a. I don't know if they did. I'm looking for a credit time memorandum. She gets no days credit on the new charge because it's all going to the F5155. So let me look to see if we had anything filed there. If not, we'll order one.
I think my date to be done with the 5 is June 6th to 26th.
Well, we're going to get a credit time memorandum just to make sure. I don't want you to spend one extra day than you have to. So, on the F6227, the court hereby imposes the fine in the sum of $10,000 plus the cost of this action. The court now suspends that fine. The defendant is ordered to pay all fines, costs, and fees within 30 days of today's date. If the defendant fails to pay all fines, costs, and fees within 30 days of today's date, the clerks will assess a late payment fee pursuant to Indiana Code 3337-522. The court notes the defendant, if indigent, shall not be incarcerated for failure to pay fines and costs. The court further orders the defendant to comply with Indiana Code 10-13610, Indiana Code 3538-127B, and Indiana Code 3538-127C with respect to providing DNA samples, if she's not already done so with the prior 7 felony convictions. We're going to order a credit time memorandum on the F6227. That credit time is at credit time classification level A as an apple, where you get 1 day credit for every 1 day spent incarcerated. On the F5, that's at the credit time classification level of B, where you receive 1 day credit for every 3 days that's spent incarcerated. I don't think there were any other charges to be dismissed. Bond, if any, is hereby released. Copy order of counsel of record in the probation department. Defendant is hereby remanded to the custody of the sheriff of Elkhart County and is ordered to transport the defendant to the Indiana Department of Corrections to carry out the provisions of this order. Copy to counsel of record and the probation department. Other than withdrawing Mr. Murphy, is there anything else that I have missed?
I have a question.
What's your question?
You said that all fines suspended, or, right?
Right, but their court cost is $189.
Okay, because you said they're suspended, but if I don't pay them within 30 days, then I was just confused.
Yeah, it's just the court costs, because I can't suspend that. That's statutory, kind of like the statutory fee of the $200 public defender fee.
Yes, ma'am, but if I'm incarcerated, does the 30 days still matter?
The clerks have to have a date,
Okay.
and since I don't know when you're really gonna get out, so, you can write me if, it's a $25 late fee, so if you want to write me and say, can you waive the $25 late fee, I will do that.
Okay,
So,
all right.
so just get them paid whenever you get out.
Okay.
All right? Good luck.
Luck today.
She wanted to go to jail. So judge sent her to jail. No problem. Ma'am, I've been waiting for this moment my whole life, ma'am. Go to jail. We got one more from her. That's just that short. Why are these all different sizes? I'll fix it.
Who's next?
Who's next?
I have Anthony Bontrager.
Let's see who they bring. Is this Mr. Bontrager?
Yes.
All right.
That's good, right?
All right, this is cause number 2402F411. This is State of Indiana versus Anthony Bontrager. Mr. Bontrager, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
Confirm.
Thank you. And sir, can you please state your full legal name for the record?
Anthony Thomas Bontrager,
And what was your address prior to being incarcerated, if you recall?
63666, Cairo 37, Goshen,
Zip code?
4612390.
And the last 4 digits of your social security number. All right, I believe we're here for disposition on a violation of community corrections and probation, correct?
The probation was dismissed, Your Honor.
Okay.
At the last hearing, Your Honor, you did state that you did not necessarily like the conditions of this plea due to the serious nature. I believe that when they were creating this plea, they were taking into account my client's mental disabilities. We set this out for dispositional after the fact-finding hearing to see if we could come up with alternative accommodations, Your Honor. We found that most facilities are geared more towards people with more severe disabilities than my client. The alternative that defense was able to come up with, Your Honor, is that Michiana Community Corrections would allow him some accommodations. The accommodation that we would be requesting is the ability for his parent or guardian, depending on how they are able to come up with the paperwork. He does have currently a power of attorney that has been provided to his parents. One of them would be allowed to come in with him and make sure that they understand the conditions of community corrections, as well as him, due to his limited ability to communicate the rules of community corrections. His parents also help him with all financial obligations as well, so they would be better able to understand those financial obligations. Your Honor, he does have some credit time, but I do believe there is a balance that would be needing to be handled today, and we ask that you allow him to do that on Michiana. His application has been renewed, but has not yet been accepted. In addition, Your Honor, I believe that this would best accommodate my client. He has already had issues in jail due to his limited ability to communicate and his religious beliefs. I believe, Your Honor, if you remember, his family is Amish, and so many of the concerns, such as the ability to access internet that you would have in these types of cases, would not be a concern if he were released.
Thank you. Oh. Is this why you're here?
Good morning.
Good morning. Ms. Becker?
I am going to defer to Ms. Campbell's argument, but this is the case that I'm here for because it is a very offensive case. So.
Okay, so, all right. No pressure there, Ms. Campoli.
Thank you, Your Honor. We agree with our community corrections. Looks like their recommendation is for Indiana Department of Corrections. As counsel noted, this was a significantly favorable plea to the defendant at the time of sentencing, and the court even acknowledged that, and I think the court almost had difficulty accepting the plea, but nonetheless, the parties agreed to this plea, and, you know, the state was willing to let the defendant prove himself to the community. You know, he made all these claims that he would do well, you know, his parents would help him out, but here we are, him violating not even, a month after he's been sentenced. His parents knew of the conditions. The defendant knew of the conditions in the terms of community corrections, yet we have several weapons in the home still. And that's very concerning given the nature of the underlying offense, his diminished capacity. County corrections that he needs to be placed incarcerated, whether that be here at the jail or at the Indiana Department of Corrections. Thank you.
Thank you. Anything else? All right. Well, Mr. Bontrager, I think you.
I am, for the record, not an excellent wife. I would probably be the worst wife ever. Ever.
Remember back when you were sentenced that I didn't like this plea from the beginning. And I told you about that. And I told you exactly what would happen today if I saw you again. And that's exactly what I'm going to do. I'm going to revoke your community corrections time. I'm going to put you at the Indiana Department of Corrections or the Elkhart County Jail, depending on how much time you have left and who wants to supervise you for that amount of time. I don't know if we have a current credit time. Oh, we do. That was filed on. So you have 156 days credit towards your 2 years in the Elkhart County Community Corrections. So I'm going to order that you serve that at the Indiana Department of Corrections, like I said, or here at the jail. Depends on who wants to take you, so to speak. Once you're done with that, you have 24 hours to report to probation. If you fail to report to probation, the same thing's going to happen. We're going to violation, and we're going to go around again. And again, I will remind you that the zero tolerance was for the entirety of your sentence. So if you violate any of the terms and conditions of probation, then we're going to have this little song and dance again. You understand what I expect of you?
Yes.
You understand what's going to happen if I see you again?
Yes.
Good luck. Thank you.
We do not see that often. We see the judges give out probation, and we hear the judges say the words, "This is your only shot. If you ever come back in front of me, that's it. You're going to jail. Do you understand? And we hear the people saying, oh, yes, yes, sir, I understand. Yes, ma'am, I understand. Well, here we saw him. She said, I don't like this plea. If you come back in front of me, you are going to jail. He came back in front of her. He's going to jail. She did exactly what she said. There was no thinking involved. Oh, yeah, well, okay. I told you. And she did. She put in that, I told you so, just to make me happy. Okay. Now we're going to go to a docket I have not seen. You guys saw a piece of it yesterday, I think. It's, yesterday was Thursday. So yesterday was the, mental health docket. Yeah, this is it. All right, let me show you guys too. Oh, I'm gonna get rid of her. And then I'm gonna show my screen. This one. I have no idea what I'm doing. I don't know why they I feel like I might have. Oh, that's right. Now we just need sound. And I think I want to start. I saw something interesting scrolling. There we go. I thought I saw her somewhere else. No. So we'll do who's behind door number 1 first. We'll go back just a little bit more because her face looks like this one might be interesting. This is Susan Blanco. She is a judge from Colorado, but she handles a lot of cases in Colorado. Now, the courthouse that she's in is in Larimer County. But if you're in Colorado and you have any mental issues, yes, I'm showing that one too. Of course I'm going to rewind it. Of course I am. If you have any mental health, if someone raises a competency issue, they put you in front of this judge, no matter what county you're in, or Judge Arnold's. But so this is the mental health docket. It's every Thursday. I'm absolutely rewinding it. Yep. Don't be ridiculous. Of course I am. That's it.
21 CR 63221 T909. Mr. Iddings is present as counsel, and Ms. Lauscher is present in custody in the courtroom. And then we have a certified Tagalog interpreter. If you'll please enter your appearance, interpreter.
Thank you, Your Honor. It's Daniel Pingle. State registration number is VC 112895. Tinatawag na po para mailagay sa ulat ng korte ang kaso ni Ginang Lauscher.
We have an evaluation back, and I've had a chance to look at it. Prosecution.
Hawak na raw ng husgado ang ulat tungkol doon sa doktor na tumingin sa inyo at meron na siyang ulat ng evaluasyon.
Thank you, Your Honor. I have reviewed the evaluation, and it
Guess what? This is not the first tag-along interpreter we had on this channel. Yes, sir.
indicates that Ms. Lauscher is not likely to be restored.
Natanggap na rin ng abogado nyo ang kopya ng ulat ng natuklasan ng doktor at sabi sa kasalukuyan wala silang maitutulong tungkol sa pagtakbo ng isip nyo.
I assume that Mr. Idding's request today is that the court dismiss the case on that basis. This is not a victim's rights case, and I would not object to that request.
Sa tansya niya, ang susunod na kahilingan ng kabilang abogado, ipawalang bisa na itong mga ibinibintang sa inyo at mawala yung kaso dahil nga wala pang may gagawang maitutulong at wala rin silang pagtutol.
Should the court grant that request, Ms. Lauscher would be released today. Her daughter is present in court and has indicated that she can pick her up from the jail. My understanding is the short-term plan would be for her to stay in a hotel.
Sang-ayon sa abogado, naririto sa loob ng korte yung anak nyo na kung gano'n ang magiging kasunduan, palalayain na po kayo at papayagan yung anak nyo na sunduin kayo sa sandaling palabasin kayo sa kulungan. At sa sang-ayon din sa anak nyo, ang kasalukuyang plano, mananatili muna kayo sa hotel at doon kayo magpapatuloy.
We do still need a long-term plan, and it sounds like Ms. Lauscher could definitely benefit from ongoing community resources. So my request today is that the Bridges appointment remain so that they can attempt to assist with that.
Sabi rin ng abogado nyo, siyempre kahit palalayain kayo ngayon, kailangan pa rin magkaroon o manatili kayo na matulungan ng tinatawag na programa ng Bridges. At hinihiling ng abogado nyo na yun din at umayon ng korte para magpatuloy na magkaroon kayo ng tulong tungkol sa pangangalaga sa inyo.
Mr. Iddings?
Judge, I would ask the court to adopt the findings in the evaluation, and I would also ask the court to dismiss the charges against her.
Sang-ayon sa abogado ng distrito, yun nga na dapat umayon sila lahat doon sa ulat na natuklasan tungkol sa kalagayan at pawalang bisa na lahat ng mga ibinibintang sa inyo at mapawalang bisa na ang kaso nyo sa harap ng korte. At hindi siya tumututol kung ganun ang guhiyan na naisin ng husgado.
The court will adopt the findings. This case will be dismissed, finding that Ms. Lauscher is not restorable to competency.
Yun din ang pag-ayon ng husgado na naniniwala siya doon sa ulat na pinadala ng dalubhasang tumingin sa pagtakbo ng isip nyo. Kaya gagamitin nyo ng korte bilang dahilan na pawalang bisa na lahat ng mga ibinibintang sa inyo at mapawalang bisa na ang lahat ng mga kaso nyo sa harap ng husgado.
She will be releasable and still have access to some of those Bridges services. And so I say that for her daughter's benefit, that you can continue to work with Bridges to come up with a plan for ongoing care and support.
And we're sure it's the Philippines. And I'm to tell you how we know we are sure it's the Philippines. Because the last time we had a tag-along interpreter, it took a long time for chat to finally land on what exactly that meant. What language are they speaking? What part of the world? Everybody was saying something different. And we finally landed on the Philippines, and that's where we're staying. And that's just what it is.
Naalam lang ng husgado sa anak nyo na nandyan sa loob ng korte na kahit na palalayain at pauuwiin na kayo ngayon, merong po siyang kakayahan na humingi ng tulong sa programang Bridges para matulungan siya tungkol dun sa paraan o kung ano-ano ang mga pangangailangan na maitutulong nila sa pangangalaga sa inyo.
This will be extremely important so there's not ongoing police interaction and there may be need for you to look into memory care and other additional supports.
Pinaalam din niya sa anak niyo na napakahalaga na humingi siya ng tulong tungkol dito sa mga bagay na ito dahil sa tansya ng husgado, kailangan niyo po binibining o ginang Lauser na magkaroon ng permanenteng plano tungkol sa pangangalaga para wag nang magkaroon pa ng iba pang aberya laban sa pulisya sa pagdating ng araw.
Right, then thank you, interpreter. We will be adjourned at this time.
Sige daw po, tapos na po ang kaso nyo. Thank you, Your Honor.
I need a disability from the other side.
Yeah, so your bridges
That's
coordinator is
English.
gonna still
That was English. That was not tag along.
be in touch with you?
Let me call the Vincent Martinez case. Mr. Iddings, you can have a moment with your client that way. Vincent Martinez is in the courtroom. He is in custody. Mr. Krenning is appearing virtually as he's double set with another courtroom. And Mr. Krenning, are you there?
Yes, Your Honor, I am here.
Okay, great. And so I'm glad that we have Mr. Martinez here in the courtroom. May I adopt the findings, Mr. Krenning?
Yes.
Court finds Mr. Martinez is competent to proceed. He is able to adequately aid in his own defense. Mr. Krenning, I don't know who is working on the FED or the sale of the home circumstances, but I do recall a while back, not involving this case, but I did have an opportunity to do a kind of like a review of magistrate order for someone who was in a similar circumstance, but they were able to gain some compliance with the bank. It doesn't actually come back to court. There is an individual in the community who is essentially titled to help with these circumstances. You can file to that person if you're in compliance in order to prevent the house from going into an auction. And so the process is a little bit unique because it sounds like I should just be able to pay the bank and then like this is over. Not quite. And so I want you to kind of be aware that in order for that housing piece to get figured out, it's a little different. You have to go away from the court essentially through that process, but you still have a way to work through this potentially.
I'm sorry, can I speak, Your Honor?
Sure.
That means that if I don't be able to get out right away, I would be able to file a motion or some kind of thing to save my house, to keep it?
So what I'm trying to say is if you're able to become compliant with the bank, there is a process to try to prevent the house from going into auction.
Okay, Your Honor.
That is not in front of me.
I understand that.
I'm only passing it along so that if there's a way for you to get some family help.
I am trying right now, Your Honor. I am trying to get out. I did that program, the RISE program, and thank you for that. That was a unique experience. It was very beneficial for me. They
All right, when you hear that they did the RISE program or they're going into the RISE program, this guy's on the right track. He's about to get out of there and go home.
helped me quite a bit with not just
Good program.
being competent, but psychiatric help, medicine, all that.
Yeah.
They did a Med-9 form for me. They said that I was had PTSD severely, and that they ruled out delusional or psychotic, any kind of behaviors. I think you probably got that, but
Yeah, and the things you've been through, let's be honest with each other. Neither one of us is probably surprised about that.
PTSD, yes, ma'am.
Absolutely, you have every right.
I
And
appreciate everything you have done for me, though, Your Honor. You've been extremely fair. I know that it seems overwhelming for me to keep coming back, and I wasn't trying to do anything out of line. I was at my house the last time, and a person lit my house on fire, and they arrested me because there was a protection order there, and I can't stop people from going to my house. That was, I know I'm probably not supposed to talk about that, I guess, but
All of that was a lie. All of it was a lie. Translating that, he went to a victim's house and set it on fire.
But hold off on talking about that, but I think what we need to do,
If I could bond out, Your Honor, if I could get out, like they told me I'd probably be able to maybe PR bond or something. If I could do that, Your Honor, I could get probably compliant. I have my house up for sale right now. I was thinking with all the stuff that happened there, that maybe it'd be better to get out of the neighborhood there.
I'm not sure that that's going to be able to happen. It sounds
Okay.
like it might be going to auction, so you need to be working. So hang on a second, you got a lot going on, sir.
I do, ma'am.
All right.
That's why I'm trying to get out really bad to get that taken care of so I don't lose everything I have.
So here's the deal, Mr. Krenning, your client is going to be returnable to my regular docket anyways, and so I'm just going to keep the misdemeanor for now, if you're okay with that, Mr. Krenning.
I'd like that.
Okay, and then what I'd like is, Mr. Krenning, you have the heart of a saint. Someone needs to figure out maybe a connection for Mr. Martinez. It's my understanding he's got some good family supports. He might be able to prevent his house from going into auction, but we need somebody who might be able to do some defense work here. Sometimes Colorado Legal Services will intervene and help in circumstances like this. There's also the Colorado Poverty Law Project, I think. And so I don't know if you have a way to reach one of those organizations to see if someone can help him with that portion of what's going on in his life.
Neighbor to neighbor,
Judge,
I had got in touch with them and they said that there was a program they could help me.
You need a lawyer.
Okay. So Judge, I actually got quite a bit of experience getting houses out of foreclosure up to the Colorado level of appellate courts. We've been successful. So I'm happy to help Mr. Martinez, and I'll do that pro bono.
How kind.
But for the moment, what we need to do is set this out back to your regular Wednesday docket. I don't think we're postured today to talk about bond because at least one of the cases I believe is VRA, and that record wasn't previously made.
Okay.
Unless the DA is willing to overcome that. But I don't know that we can talk about bond today. The one big one is at 25,000 cash.
I have the burglary count has a third degree assault as well. I have another third degree assault that was in originally Loveland's county court matters. And so I do need VRA and we do need to reset this. Let me bring us back. And I don't mind doing that, Mr. Krenning, if we can address bond when we come back. I'm looking at the 10th of September potentially, though I think you're not available that day, Mr. Krenning.
Right, I'll be in Missouri that particular
How
week.
about the 17th at 10 a.m.? Are you available?
That's fine. That would be just fine.
Let's do that, September 17th at 10 a.m. And then people you're on notice, we will be addressing bond at that time.
Okay. And Vincent, I'll meet with you at the jail now that you're back from Rise. We'll get all of this stuff outlined, and I'll do what we can to get this house situation stabilized.
This is Colorado. We're watching Colorado right now. Anthony,
Thank you.
Sorry.
All right, hang in there.
Thank you.
You're welcome. Thank you, Mr. Krenning.
Yes, have a good weekend to everybody there.
Thank you. Dawn Martinez, 25M132, 25M518, 25M440 is present before the court, and she is in custody. Mr. Britt is present as counsel for Ms. Martinez. Are you all related? No? Okay, I don't know. I've got two Martinez's back to back on my docket. I didn't know. I thought I would ask.
Me.
Right.
Warner, I think.
Okay. So I did find that there was a report evaluation done. Ms. Martinez, thanks for getting that evaluation done. Mr. Britt, any objection? Any objection from the district attorney?
No, Your Honor.
Okay, so I'm going to adopt the findings at this time that she does need some support to aid in her own defense.
No.
Now we have some complications,
No.
so I need some help. What is happening in Adams County?
Yes, Your Honor. Thank you very much, Ms. Lowry. We got in touch with the Adams County Public Defenders. She's back on the docket for them. Her next court date is September 10th, I believe.
Okay. Does she have a bond in that case yet?
I understand she's being held on a cash bond in that one, and that was the complication.
The complication was I was in jail here
I'm in
on this
jail.
other case that, anyway, I was already in custody here, so I had a failure to appear there.
I see. Well, so at least you have a court date there, so now we're getting someplace here. And
Can I just say one other thing?
sure.
I've been in jail, and I called Mr. Britt when I found out he was my attorney, where he informed me not to call him again because he would have to make billing arrangements. Then he came to see me and let me know that I wouldn't like him. Then I never get to talk to him before court. I have no idea what's going on.
Okay, so what's going on right now is we now have a court date in Adams County, so that gets things moving. And I need to bring everyone into court for your potential release from the jail. But one of the things I'm having a hard time with is most of the people I know that are in our court process, they are meeting with a doctor to evaluate whether medication is something that would be helpful. You have not met with a medical provider to assess your medication needs. Would you be open to doing that before we come to court?
What I need is, I'm sorry, would you repeat that?
Would you be open to meeting with one of the doctors who can help discuss the potential of using medication? Most of the people that work in this court do utilize medication, most of the clients in here, but you haven't even met with a doctor. Are you open to meeting with a doctor to discuss that?
No, I had a doctor, and I was on gabapentin and all kinds of things for.
So are you open to meeting with the doctor again? Because I don't think that they're currently giving you any of your prescriptions.
No, because I need to see a doctor. I was in a car accident and haven't had any care for my spine, and because I've been homeless.
Those are two different types of doctors. I'm talking about for you to meet with a psychiatrist.
Oh, I don't take psychiatric medications.
Okay. I think you just labeled a medication that you're on previously that was prescribed to you.
For what?
Can you give me that list again? You just made a statement to me a moment ago.
I was on medications for a severe spine injury.
Okay.
There was 5 of them, but
Gabapentin is pain, isn't it? That's not psychiatric. Isn't that just pain medicine?
They kept mixing them together and doing awful things with my medication. So I quit taking them. And because I was on 5 medications and released from the hospital 4 hours after I quit vomiting from a pain medication they gave me that I was allergic to, and I was still coming out of anesthesia, and I got home, and 2 days later when I could really start to focus and think again, because I was on all kinds of meds that had never taken anything more than 2 Tylenol or ibuprofen. So back in 2000 and I think 4, after my husband left us homeless, I tried Prozac for a little while and I got off of it. My issues isn't with mental health, it's with people abusing medications and lying and deceiving and hurtful words. So I am not on or have I been taking any kind of psychiatric medications. I'm not depressed, I'm angry. I get up in the morning every time, on time. I go to bed at the same time normally every day. I continue to help people in my pain. I wait for my attorney to call or come by. I'm frustrated, I'm angry, and I am appalled at the idea that I'm not to call my attorney for anything because he has to make billing arrangements.
I don't have it.
I'm frustrated with the system and that he, knowing my situation, would not have me out of here. And I had an appointment with an attorney to discuss my long-term disability, a private attorney.
I'm extremely,
flowing from
just a
in my
moment,
direction,
ma'am.
and he doesn't care.
Sir, just ma'am, 1 second. I am very concerned from reading this evaluation, and I'm just looking at it again to refresh my memory because it just to me does not make any sense that there is going to be much success without medication interventions on an outpatient basis, but I'm happy to stand corrected. Prosecution?
Your Honor, the people are also concerned about that, and would ask that there be a plan before she's released, that would include some medication management.
Mr. Britt, I would give you an opportunity to respond, but I'm going to just tell you I'm very persuaded by the report that I've read. This is a long history. Your client, if she doesn't request to be essentially evaluated by the psychiatrist, they're not going to send anyone out to visit with her, is my understanding. I'd be happy to order, but again, if she's not willing, it's not going to make much difference. I'm going to order inpatient restoration at this time. I'm happy to revisit that finding. I understand that there is a way we might be able to work with your client in the community, but not if she's not stable on medication. And so at this time, I'm happy to bring this back. I'm happy to bring it back after her Adams County case. Let's set this for September the 18th at 3:30 in the afternoon. Ms. Martinez, I highly encourage you to make a request to visit with the psychiatrist. A lot of the things that you're feeling and experiencing might be things that you could have extra support, feeling paranoid and having some of this dysregulation that you're describing.
Who said I was paranoid?
Like being angry and being upset. And
If I wasn't angry, there would be something wrong with me.
And it does very much seem like you would benefit from having an appointment. I would encourage you to do that. That is at no cost to you while you're in the jail. So get the tablet, make the request. I certainly would like to consider if you've made some progress on that front. Mr. Britt, if you'd continue to do your best to encourage it. Otherwise, are you available on September the 25th at 3:30, sir?
Yeah, I'm sorry, Your Honor, my phone died, so I can't double check.
Okay. Could you accept that date? If there's an issue, let us know. September 25th at 3. It's a Thursday at 3 in the afternoon, last date in September. That's after the Adams County case. Everyone's on notice. We'll address bond potentially at that time. And I'd like to give some time for Emily to keep working on a plan with Ms. Martinez, but medication is going to be a huge, important part of this process. Thank you. Edgar Allman, 25M 1357, 25M 1252. He's present before the court. He is in custody. Mr. Iddings is present as his attorney. Hi, Mr. Allman. How are you?
I'm fine, thank you.
You are doing great. Thank you for working with the doctor at the jail. You are 100% medication compliant. And have done a really nice job of working with the resources and working with Logan. So well done. Mr. Iddings, your client has done very well. He is got an evaluation that came back that he is competent to proceed. May I adopt the finding?
Your Honor, I don't object to the court adopting the finding as long as Bridges can stay on the case for up to 90 days. I don't think he's actually had an in-person visit yet, and he just has some things that he needs help with that he'd like to talk to Bridges about.
Logan, are you able to continue to support Mr. Almond afterwards with no additional order for extra 90 days? Is it 60 or 90?
It's up to 90.
Okay, perfect. So Mr. Almond, that's already going to be available to you, so you don't need an extra order. I am going to find that you're competent to proceed. Your next court date will be with Judge Ellison back in courtroom 4D on September 18th at 1:30. Keep doing the good things that you're doing to take good care of yourself. It has gotten you through this portion of the case. It'll serve you well for Judge Ellison to know the things that you are doing to take care of your wellness. So keep it up, okay? All right. Anything else, Mr. Iddings?
That was Division 4D?
Yes.
Okay. Nothing else.
September 18th, 1:30, Division 4D.
Thank you.
Thank you. Have a good day, Mr. Almond. Nice to see you. Patrick Erickson, 25M55, 25M168. Yep, I can pass that case. How about Timothy Kemble, 21 CR 1567, 24 CR 1454. Mr. Kemble is present. He's out of custody of Mr. Iddings here as counsel. Mr. Kemble, it feels like I'm getting blown off by you, and I don't know that you mean to do that, but since March, you haven't had any contact with pretrial services. So I don't want you to panic. I don't want you to panic. I'm going to give you an opportunity to get back on track with pretrial. And so we need to do that in order for us to be able to keep you out on bond. Morgan also wants to connect with you, so connecting with Morgan will be important. Mr. Iddings, Brandy's here from pretrial. She'll have information on how your client can get back on track with pretrial services. In the meantime, can I adopt the finding?
Your Honor, I don't object to the finding.
Mr. Oxmacher or Ms. Lechuga, any objection?
No, Your Honor.
Okay, I'm going to adopt this. I do need an outpatient restoration plan. Does Morgan have one available? If not, I can pass it for a moment. Sure, I'll pass this, Mr. Kemble.
Yeah, if we can.
Let me just pass it for a moment, and then Mr. Iddings, I'll give you a moment to meet with him too. And
Your Honor, we have Miss Leatherman from the jail.
okay, wonderful. Naomi Leatherman, 24M2597, is present before the court, and she's in custody. Ms. Lowry is here in the courtroom as your attorney, Ms. Leatherman, and I'm glad you're able to appear virtually today. And let me just check in and kind of see maybe what we're doing as far as whether we need an evaluation or not. Let me check with the lawyers in the courtroom.
Thank you, Your Honor. This is a case that Mr. Axmacher is open to a 1355 referral. We know Ms. Leatherman from the docket last year. She was evaluated. She was never restored, and her cases were ultimately dismissed. The state hospital pursued a civil certification, but I don't know how long. I don't know what happened to that, but she was ultimately released. I appreciate the effort to try to do something differently this time. I think that we need about 30 days for Morgan to do the intake for 1355, though Morgan did tell us that, or did say that she'll let us know in the next couple of weeks if Miss Leatherman is just too acute to participate in the program. My hope is, Miss Leatherman, that you'll take the medications, that you'll talk to Morgan about 1355, because this could lead to the dismissal of the charges and maybe get you some stability in the community rather than just going to the state hospital again.
All right, Ms. Leatherman, I'm going to essentially reassign within the Bridges program, Bridges to actually work on the 1355 process. We have to substitute our JDF order on this case. But what does any of that mean to you? Morgan is going to come meet with you. You are going to be screened to see if you're a good candidate to work with Bridges instead of going to the state hospital. So what are some things you can do to be a good candidate for that program? You need to eat good food, put food in your body, and take good care of your health. And you need to take your medicine 100% of the time the way it's arranged with the doctor. You only do it 1 out of every 3 times. That's not enough for it to actually get to work for you. So you need to follow doctor's orders so that you can feel better. That way you might be able to avoid going to the hospital. So on your own, please eat good food, take your medicine the way it's prescribed, and then Morgan will be out to visit with you to see if you can participate in this special program. Ms. Lowry, I'm going to bring this case back in 4 weeks then.
Thank you.
September 25th, we'll set this matter in at 1:30 in the afternoon.
Adam's my soulmate. Everything I just heard in this whole case, all I really heard was good food. That's what I heard.
And we might be having a disposition or a potential bond review at that time, Ms. Lowry.
Great.
Okay, we'll have everyone back then. Morgan will be out to visit with you soon. All right, thanks, Ms. Leatherman.
When do I get to leave?
You don't get to, thank you, Mobile 3. All right, do you want me to continue to pass the Erickson matter? Sorry, I didn't know if you were meeting with him or waiting for him.
I'm waiting.
Waiting? Okay, I'll just keep passing him. And then, are you covering Mr. Landers' case, Ms. Muniz?
Mr. Iddings is, why don't I just see if I can.
Okay, that's fine, because I can call her case next.
I love that cup. I do love
Mr.
that cup.
Iddings, let me
Big
call
fat bottom
the
on it.
Muniz matter, please. Yvette Muniz, 24 CR 43325 CR 589. She's present before the court. She's out of custody. And Mr. Iddings is present as counsel. Hi, Ms. Muniz. How are you?
Hello, I do not consent. This is not my attorney. He doesn't even know what I look like. How many cases do you have, sir?
So he works with Mr. Landers, and I'm assuming Mr. Landers is not available this afternoon.
No longer available.
And
in
this
court.
case has been transferred to me now that Mr.
I don't
Lang-
consent.
And
I do not consent.
Okay, that's fine. I understand, though we cannot tell them which lawyer is going to be handling your case. Ms. Muniz, North Range Behavioral needs you to sign a contract with them, otherwise they're going to discharge you. If they discharge you, the only other option is for you to go to the hospital. I really would like for you to stay in the community. You have a kiddo, you are able to go to North Range, so you need to get this signed so you don't get kicked out of their program. I only have two options under the law. One is to send you to the hospital, one is to work with you in the community, but the classes are one of the requirements by law. So you
There's very few. I've never seen a sub sit in here. I've never. I don't know why, because I think they are all a little mental. But no, these people are just mental to begin with. They're here because competency has been raised already.
have to take the classes. So I need you to look at this paperwork, because if you don't get re-engaged in that program, you're at risk of having to go to the hospital. So let's not, you and I, get stuck in that situation. I want you to stay in the community. I need your help.
He just said he's gonna lose my case.
No. I was letting her know that if she goes to jail, there is a waiting list to go to the hospital.
That's
It's about
true.
300 days, and she could lose her kid if she's in custody that long.
That's true.
Oh, like y'all stole my kid for no reason, for me trying to survive in this community.
So I'm part of your criminal case. I don't know anything about what happened with your child. I'm sorry to
What
hear.
happened was that y'all used government overreach to try and steal my baby and broke me psychologically, which is how I ended up here with complex PTSD. How many cases do you have, sir?
Okay, Ms. Muniz, I'm going to give you a moment to go over this
Tree fitty.
paperwork. I don't want you to go into custody. Please look
Are
at the
you saying that
paperwork
if I don't sign this document, I'm gonna be in custody?
per your choice, because we have two
I don't have
options.
a choice. I have to sign this document or else I threat of incarceration. Is that what you're telling
You're
me?
either going to go to a hospital to do classes or do them in the community.
If I don't sign this paper.
North Range Behavioral needs you to sign that paper, or they will not let you do their program. So you either are going to be in good graces with North Range, or you're deciding that you're not going to do the classes in the community. You're the one who's driving.
Y'all want me to do dysfunctional thinking classes because I made a dysfunctional choice after y'all broke my psyche by trying to use government overreach to steal my
I'm going
child.
to give you.
Look at my teeth. The police knocked my teeth out. These are serious charges, correct, Mr. Prosecutor?
Ms. Muniz, you are excused.
Accountabilities, yes, ma'am.
I need you in the hallway for 5 minutes.
Yes, ma'am.
Take a deep breath,
Yes,
look at
ma'am.
the paper, and then come back in, please. That's pretrial services information. Mr. Iddings or Ms. Lowry, if you all can help. Because Mr. Landers is not going to be here, so let's see what we can do to kind of help her. I don't know if she does better with a female attorney or not.
She tries to keep her voice even because of this situation. It's this close to that meltdown, every person that comes up.
I know that's really, it's up to you all. Oh, you are equally rejected. How nice.
This is the extra copy.
Oh, okay, finish. So trying to, I just call it my.
Did she say pizza?
Let me just drop it off desk, and so.
Emily, I don't know if there's,
Well, she. So we don't need the other one.
I don't know if there's anyone from Bridges that she works well with that she might be willing to. Okay.
I'm ready to recall Mr. Kimball.
I know you're ready to do that. I think we just need to figure out how to support her so that she might not end up with an inpatient. And one of you that has a soothing personality might be a good combination to go and help. Not that you're not soothing, Mr. Iddings. let's go ahead and call Mr. Timothy Campbell's matter back in 21 CR 1567, 24 CR 1454. Now Mr. Iddings is still in the courtroom as counsel. Mr. Campbell, you got a plan? Okay, great. So let's get back on track. And then do you have an outpatient restoration plan, Mr. Iddings?
We're having some issues getting it printed. If you can
Okay.
give us a couple minutes.
Well, I can, or here's the other thing I can, why don't I order, well, let me give you a couple minutes. Let's pass it for a couple minutes till their printer connection is working. All right, I'm going to take a recess till 3:30, and then when I come back, we will kind of catch back up. Thank you all.
Okay, we're going to keep going with her because she's having a good day. I was going to go to Judge Eric Johnson for a bit, but we're going to keep going with Blanco.
Oh, good work. Good work. That's a good aspect.
I wonder, all right, it looks like, and I could be wrong, it looks like this is her. So, hi Sherry.
Client, and we have the outpatient plan. All right, Mr. Campbell, you have to be bond compliant, and I am going to adopt these conditions on your bond, and that is that you go to the outpatient classes. You live here locally?
Most of the time I do.
Okay, so if you're going to be here, then that referral is going to be probably at Summit Stone. Those are the classes on the law you have to take. It's either in the community or you have to take it at the hospital. So this is in order to do it in the community. Keep working with Brandy and Morgan. Make sure you return their phone calls. Do your standard pretrial supervision. Don't drive without a valid driver's license and insurance. You need to be law-abiding. Report to your probation officer within 24 hours. And just make sure that you're not harassing, intimidating witnesses, victims of the case. And then keep living at this Shoup Street address in Loveland. Is that where you normally are?
Yes, sir.
So the classes are in Loveland too.
Yes.
So they'll refer you to those classes. I'm going to adopt these as your outpatient orders. I'm going to just kind of want to check in and make sure that you're back onto that bond compliance piece. So let me give you a copy of this order as your outpatient restoration plan. And then Mr. Iddings, I'd like to give your client a few weeks here to get kind of settled in and see how things are going. Could your client be available at 4:30 on September 25th?
That'll work.
Okay, let's do that. That way I can make sure the classes are started and that you have a few weeks of good track record, okay?
Thank you.
Thank you. Please do that so that we don't have to address your bond, okay? Thank you. And then let's also recall Yvette Muniz and help her get out of here. And her case numbers, again, for the record, are 24 CR 433, 25 CR 589. And
Your Honor, I haven't had a chance to talk with Ms. Muniz. I mean, frankly, the transfer of the lawyers has been pretty traumatic, and she's
Sure.
like a private attorney appointed outside of her office. But she also indicated that she would be willing to talk with Mr. Iddings if you would set this over for 2 weeks. We were going to see if maybe North Range might adjust some of the language. You
can. That's fine. Let's set it for September 11th at 4:30. And then we'll come back at that time. That's fair. I understand, Ms. Muniz, you've never met this attorney before. We'll come back in 2 weeks. See what you can figure out with North Range. The whole goal is for you to stay in the community. And so if you can figure that out with North Range, that's fine with me. I just want to make sure that you're taking the classes in the community so that we can keep you in the community, okay? So we'll come back in 2 weeks, September 11th at 4:30. Thank you.
So.
And then I'd like to call Brandon Marshall's matters, Ms. Lowry, 24M16, 23CR835, 24M5092, 24M5206, 24M5221, 23M1636, 23M5324, 23M701, 23M644, 24M792, 24CR988, 25CR574, 25M852. Mr. Marshall is present before the court in custody. Ms. Lowry is present as counsel. And then I have Special Prosecutor Ms. Fitzgerald also here, as well as our local attorney, district attorney's office as well. So, folks, it's my understanding that there might be some sort of a plan. Mr. Marshall, I'm going to be open-minded. I am exhausted of this. I'm just going to be honest with you. I don't know how the other people who are around you feel about this. I'm not going to even ask what your mom, for example, might be feeling at this point, but I am tired of this. So I'm just telling you now, and I'm letting the lawyers know, if this goes favorably for you, this is it. If you can't make this work, you are, from my perspective, needing to go into longer term care at the state hospital, or quite frankly, if you're competent, you need to go stand trial and deal with.
All this man has to do is take his meds. If he just takes his meds regularly, this judge is super happy. You can mess up all you want. You can do whatever you want. As long as they tell her, yep, taking the meds 100% of the time. This judge is just so pleased with you. And you get head pats, and you get, good jobs, gold stars. She's mad. I'm guessing. I don't know. I'm guessing he's either taking his meds 30% of the time or less. I don't know. We will see.
These cases, I have 13 cases on the docket. This is getting old, quite frankly. So, Ms. Lowry, I will be open-minded to this plan and your arguments, but I'm just telling you, it's just a pattern that has been, quite frankly, extremely frustrating. And I partially blame counsel, not you, but defense counsel, for dragging out when he was competent and able to move his cases, because we just kept continuing and continuing and continuing. And I'm not going to do that again, just to be transparent. That was not you. And I love your counterpart, but this was not my favorite moment. So, Ms. Lowry.
I do think most people know more about these cases than I do, but I have been working with Mr. Marshall. I have talked with his mother, who is here today as well as some neighbors who have been supportive of Brandon in the past. He has a bed available at work release starting on September 2nd. He has a bed at Sturt starting on September 15th. He has had, while he's been in the jail, no write-ups. He's an inmate worker, as you can see. He's 100% on his medications.
Physician assistant. It's like as close to a doctor as you could possibly be. They can write prescriptions, right, Sherry? Right?
And historically, he has done well in structured settings. He's been to work release successfully before. His mom highlights how he was in the halfway house in the past. That's maybe the best he's ever done, is stability, work, therapy, medications. He's 268th on the list to go to the hospital. I appreciate that this would be the last opportunity. I think he knows that as well. Sobriety is his number one issue. I think that can be told from the cases, and this plan addresses that specifically and keeps on a pretty short watch. I did file proposed orders to dismiss L24M16 and 25M852, given that the charges are not serious enough to support restoration. And I'd ask the court to consider modifying the bonds to personal recognizance bond, putting him himself on the hook for the amount of money should he not participate appropriately in work release, sturt, or return to court dates.
Does he have a co-signer?
I don't think at this time his mother is prepared to be involved in the cases.
Can he post low cash bonds?
I don't believe he has any access to any kind of cash, Your Honor.
Okay. Any objection from the prosecution, the dismissal of the two cases that legally qualify for dismissal given the findings?
And I'm sorry, can I get those two?
Yes, sorry.
Yes, 25M852 and L24M16.
I'll need to research those
If you
real
could,
quick.
yes, I'll let you do that in a moment, but first let me hear your argument, and then I'm going to give Ms. Fitzpatrick a chance to be heard too.
Thank you, Your Honor.
Ms. Fitzgerald, sorry.
Judge, we know that Mr. Marshall, when he's sober, can be successful in the community. We've seen that. We've seen him go to treatment before. We've seen him on track, and then we've seen him fall off track. Ms. Lowry just made the point that he is number 286 or whatever. When we took a risk on him before, I recall making exactly that same point. If we let him out today, he's going to lose his place in line. And the court is taking a risk in doing that. I share the court's hesitation. I suppose my position is if the court is willing to take a risk on him one more time, my proposal would be that we start with STIRT, complete that, and then transition to work release, as opposed to work release, STIRT, work release. I think given his demonstrated history that sobriety until STIRT and then 21 days of sobriety through STIRT is what would best set him up for success.
Okay.
And so ultimately I defer to the court, but do have some hesitations.
And if he goes into STIRT, you are in agreement to PR bonds being appropriate on the cases you are prosecuting?
I certainly appreciate the court's question about a co-signer and who else can be a partner in making sure this is successful. But, we did release him on PR bonds before. It went well until it didn't.
Well, that's accurate history. All right, Ms. Fitzgerald, your thoughts?
Judge, I echo Mr. Oxmacher's concerns as well as the court's. I know that when he was out, there was a new law violation, I think a felony in nature. And so I do have concerns that he'll remain compliant. But noting that I have one case and he has several others, I would also defer to the court along with Mr. Oxmacher.
We will return to court on September 11th. We will return to court at 3 o'clock in the afternoon for potential bond review to examine whether or not it is appropriate to allow him to take a bed at STIRT on September 15th. Mr. Marshall, it may be the case that I give you low cash bonds or co-sign PR bonds. I am not sure what that's going to necessarily look like. I don't know if you can make amends, but I do think it's good for you to have other people for the benefit of somebody who has 13 cases in front of this court. I think it is helpful for us. Normally, we don't have people over and over and over and over again getting the benefit of a PR bond. In circumstances like this, put some thought into it, make phone calls, have conversations. I'd like to know what other options are available other than just a PR bond. And I agree with the district attorney. You do well in structure, you're going to go into STIRT, and then you can step down from there. But I'm not ready to move you over into work release at this point in time. I, quite frankly, am not impressed with the way things unfolded with you last time we went down this path. Ms. Lowry, I don't know if there is, are you on a process of getting a second evaluation, or are you, we've adopted?
You adopted the findings on July 31st, ITP Tier 2.
And the only reason I ask is because when Mr. Marshall is sober, he's usually competent. So he might not need to be stuck in these circumstances. I am going to ask the DA, do you have an objection to the dismissal of those two cases, Mr. Oxmacher?
Yeah, I definitely object to the dismissal of 24M16.
Okay.
DUI charge in that, and so it is therefore not eligible.
All right, court denies the request in 24M16. I just want to make sure that that
I
does
did
not.
not see that. I apologize.
I just want to make sure that that does not end up in my inbox and accidentally get signed. So we will deny that at this time. And then the other case? It's a resisting, obstructing, and failure to leave premises.
So, Your Honor, I believe that procedurally in that case, we have not adopted a finding.
Okay.
I agree that there are 2 class 2 misdemeanors or 3 class 2 misdemeanors in that case, that it would be eligible. However, I concur with the court that normally Mr. Marshall, when sober, is competent. And so I am not willing to concede today that with respect to that case, he is not competent. And if Ms. Lowry seeks a dismissal in that case, I think we would need a current evaluation
Are you
to
asking
make
for a
that finding.
second evaluation? Because
The
I
court
think,
adopted findings on 28 days ago.
just one moment, are you asking for a second evaluation to be completed?
I am.
This isn't a second evaluation. You already adopted the findings. I mean, a reevaluation, I suppose, potentially, but you've already adopted the findings. They didn't object in July. And so he's on the list for the hospital ITP tier 2. If the DA thinks there are changed circumstances to support a reevaluation, I saw that it said order to receive competency
Ms.
evaluation
Lowry,
order.
I appreciate how passionate you are. Just a second.
And Your Honor, I guess I was not present in court on July 10th.
I'm just reading the minute orders from July.
If she doesn't get upset and she changes her whole personality to make sure that the inmates and the defendants do not get upset, she gets really mad when a lawyer gets upset because they know better. They know better. They know better. They're allowed to fight for their client. They're allowed to fight for their client, but they are not allowed to do it in an upset way, because that will. The thing is, it's like a wildfire in this courtroom. If one person starts screaming and yelling and things like that, it agitates the rest of them. Now, there's more who are watching from their cells on Zoom than what we see. And when one gets upset, they all get animated. They all get agitated. If there's usually some more in these chairs right here, they all get a bit. So that lawyer stepped way over the line there. It didn't sound like it. It wasn't crazy. It was outstandingly over the line. Hi, Walter.
10th, I appointed Bridges. I ordered an in-custody evaluation and continued the matter to address bond, but I did not adopt any findings according to this unless there is an error in the minute order. So if you could double check that.
It's just you did adopt findings in other cases. If it didn't get adopted in this one, that's because otherwise it wouldn't be on the list for the hospital. I think that was an oversight.
Well, that was on July 10th. I don't know if that case didn't make it to the docket on July 31st.
Let's see.
Because July 31st is the date I adopted findings on the other cases. I don't know if this case was called on July 31st or for some reason, because as you can see on the July 10th minute order, it says this matter is continued to August 21st.
And this is what happened. Behind the scenes, we did see that one case got randomly put on last week, and so we added it to this week. So it was this matter.
I'll let you all figure that out. I'm not going to dismiss anything today. Let me let you all talk. I mean, figure out what you all want to do. Isaac has also come forward. We have now made Isaac stand up. Yes.
I have a list of the cases that are ordered to inpatient restoration.
And this one's not on it?
Which one are we asking about?
We're asking about 25M852.
Okay, that one is not currently on the list.
So I get what both sides are saying. Ms. Lowry, can you work on this and see where we end up? September 11th at 3 o'clock, I will readdress bond. Mr. Marshall, please have multiple options if you can available. Look into whether you can have a co-signer, please, so that if there's some alternative options, we can consider all of those. District Attorney's Office, please be VRA compliant to address bond at that time. Ms. Fitzgerald, does that time work for you?
Yes, it will.
Okay, great. And you can be virtual and we'll be back at that time. Thank you.
Thank you, Your Honor.
Really quick, if you guys have an extra 15 minutes today and you haven't already, I put a video out yesterday that's sort of floundering. If any of my subscribers watch it, that will help a lot. I just put the link in chat. It's 15 minutes long. If you don't have 15 minutes, don't worry about it.
And then when we come back, if you still need the second evaluation, you can let me know, Mr. Oxmacher. I'll let you all have a conversation before we do anything more. And then, do I have Sherry Ann Autry, 22 Sierra 1897, 24 Sierra 1286? She's going to be virtual, and she is. Let me just give her a chance to get her camera on and get unmuted. Her lawyer, Ms. Lowry, is here in the courtroom. Ms. Autry, I'm going to send a request to unmute you. There we go. Yep. Can you get your camera on, Ms. Autry?
Hi, yeah, sorry. I was
There
talking
you
to
go.
my cousin and my friend.
That's okay. All right, your lawyer, Ms. Lowry, is here in the courtroom. It looks like, give me 1 second. One moment. All right, so Ms. Lowry, are we okay to adopt the findings?
No, Your Honor, I am asking for a second evaluation. Again, Dr. Hatfield, because he was doing the others, would agree to do this.
Why can't a man say that to me? Why? Why? I just don't. I'm just so, Nan, I'm just so upset right now.
Virtually with Ms. Autry, and can file a report in 6 to 8 weeks.
So I don't need to authorize any additional funding.
No.
Court will appoint or court will order a second evaluation be completed by Dr. Hatfield. And so we'll set this out about 6 weeks, it sounds like, to get your evaluation back. Ms. Autry, ask that you make sure you make the appointment with Dr. Hatfield and keep up your good work. It seems like overall you have been doing well working, and I know that you and your cousin are looking for housing. I just want to make sure you're still doing your pretrial services and you get on track with that piece of things. So Ms. Lowry, if you could help and make sure.
Yeah, it looks like they've worked out a plan. I appreciate that Brandy's been willing to send Sherry Ann a notice that their meeting is going to be the next day. I got like 12 notices that I have a dentist appointment coming up, so I appreciate that she does that.
Okay.
And that should solve the problem.
And then last thing is, I just want to order that the outpatient restoration, that continue while the second evaluation is being completed. So Isaac, I'm not sure in that community if they need this to be actually ordered out loud in the courtroom, but I will out loud order that outpatient restoration just continue because I think that will be helpful. Thank you, sir. All right, let me get you a new court date. Just one moment, Ms. Autry. I think if we could have you back October 9th.
I'm so sorry. I'm gonna pull up my calendar so that I could put it in my calendar.
That's fine. October 9th at 3:30 is what time I'm looking at.
Okay.
Does that work for you?
I will make that work. Most definitely.
Okay. All right. Well, then I'll see you back at that time. We will have more information, and then just keep up your good work. Stay in contact with everyone, okay?
Okay, thank you so much. I appreciate you.
You're welcome. Have a good day.
Thank you. You have a good day as well.
Thank you. And then let's call matters of Christopher Brown, please. 24 CR 573 and 23 CR 1518, 24 CR 1536, 22 CR 722, 24 M901, 24 M5085, 23 M1989. He is present before the court and he is out of custody. Mr. Iddings is present as his attorney. All right.
So I have thoughts about this whole hype thing. I'm pleased as heck if someone hypes it. Don't get me wrong. But the best thing for a channel is if people who are interested in that content watch that content. The worst thing for this channel is if it goes out to a bunch of people who are not interested in that content. Because if they're not interested, they're not going to click. If they don't click, then numbers go down. Like they have to, if YouTube pushes your video into like suggested or their home feed and they do not click it, your numbers go down. So You hype it, and then YouTube says, oh, this is a really good video, and they push it further, which is a little worrisome because if they push it further to people outside of like court watchers, then it would not be good. That's why, if you guys know someone who likes court videos, yeah, suggest this channel. It's a fun channel. But like if they don't like court videos and then you suggest this to them and then they're a sub and then they don't watch anything, that's bad. That's really bad. So I don't know about this hype. I'm a little it just feels to me like it's a failure, like it's going to pull numbers down, not up. But maybe I'm wrong. Maybe YouTube is smart and they know who to push a video to, because they actually don't push videos out. That's not how YouTube works. YouTube looks at a user like you and they pull videos into your page they think you will like. They don't take my video and push it out to 1,000 people. If 1,000 people have court watching interests, then they will pull my video into their thing. So I haven't seen hype yet because I haven't watched any videos on YouTube. Maybe I'll go to Law Talk with Mike today, watch his latest and hype it and see how it works. Or American Courts. I'll hype American Courts every day. All day long. I'm doing it right now. I'm not.
Great. Hi, Mr. Brown. How are you today? Not feeling too good? Okay. Well, thanks for being here even when you're not feeling good. I think that you had just recently, yesterday, got out of the hospital. Is that right? Okay. Well, I'm glad you're here today. So I think what we need to do, Mr. Iddings, do you have an outpatient plan?
Yes, may I approach?
You may. I think what we need to do is give a little time to get back on track with pretrial services. Mr. Brown, you have not been really doing what you need to do with pretrial for a year. Not like just recently while you've been in the hospital, but like 1 year of our time together, okay? So you need to be doing pretrial. Brandy is here. She will give you some information how to do that. And you're going to need to do that as part of this order of the court. Do you understand? Okay, so you're going to need to take the classes at Summit Stone and stay in contact with Brandy and Kenny. Can you do that? And then you're telling me on this plan, you're going to have no alcohol, no controlled substances, no marijuana, and you're going to do random UAs, daily BAs, 2 times a week UAs with ETG authorized. Don't drive without a valid driver's license, insurance. Remain law abiding. Don't leave Colorado without permission of the court. And no weapons, no contact with the alleged victims. And I don't have, oh yes I do, Taylor Hash, Officer Berenberg, Shawnee Valdez, Latoya Valdez, and Sunny Brown. Are you so far able to do all of that?
Your Honor, I have concerns about him doing daily BAs just because he's dependent.
Mr. Ames, I have a concern. He's not even going to call pretrial. I am thinking maybe the smartest thing to do is set this over a week or two before we adopt any plan. And let me just see if I can get him to engage with pretrial and see what we can do. But I'm open. If you want me to adopt, I will order this plan, but just to get him started with outpatient referral going in and then come back in a week or two and see if he's actually making contact with pretrial.
Yeah, how about we come back in 2 weeks? And if the people could be VRA for potentially modifying some of his bond conditions in terms of frequency.
He has gone through this. Mr. Brown, you need to give UAs, you need to give BAs, you need to be tested so I make sure you're sober. Do you understand? You have to take medicine as prescribed by the doctor. And then you need to continue to reside at your Fort Collins, Birmingham address. Are you okay with that? All right. I'm going to order these as conditions of bond in all cases and order outpatient restoration consistent with this plan. Mr. Oxmacher, I'm not sure the medical conditions, whether it's necessary to have this high of a level of frequency for all of these requirements, but they are redundant because there's 7 cases, and I think they kept setting bonds and adding whatever was appropriate for any particular case. And so could you look at that and be VRA compliant? I want to come back and see if he's pretrial compliant and if we can clean up the conditions of pretrial.
Certainly, Your Honor, but when compliance has been 0, I think modifying is.
No, if he's wheelchair bound, usually do you need daily testing and ETGs and all the other things that are there? So yes, Brandy.
So he can have a breathalyzer unit that he can do daily breathalyzers from home.
Wonderful. So let's try to get him compliant with bond. We've already ordered outpatient restoration plan on everything so that it'll get the referral going for the classes. Are you his relative?
I'm his nephew.
Okay, does he live with you?
No.
Okay, does he live on his own?
Your Honor, he's just been staying with various family members. The address on the plan, the outpatient plan, that's his mailing address only. It's like a permanent mailing address, but because he's dependent on family members, basically to move him anywhere, family members are taking turns
Caring for
watching. Yes.
Can you're his nephew, what's your name? No, Nolan? Noah? Okay, Noah. It would be really helpful if we have each of the addresses of who is helping care for. It sounds like everyone's sharing that responsibility. So if we could just get a list of the addresses, because that's what's actually supposed to be on here is not his mailing address, but where he's going to be living in case he's missing from classes and we need to like get back in contact with him first. So if you could help him with that piece of it, because that needs to get organized and communicated. And the other piece of it is whomever is helping care for him, and sorry to speak over you, Mr. Brown, but I feel like I'm not even sure how much you're able to gather of what I'm talking to you about right now in the courtroom. Whoever's helping care for him, he has to go to these classes once they start, and he has to do pretrial. If he doesn't, he's going to either end up in the jail or in the jail to go to the hospital. So if we want to keep him out of jail, he has to do pretrial and he has to go to these classes. So I'll give a copy of this, but whomever is helping care for him, they need to know that because they're going to have to help him figure out how he's going to do that. Does that make sense? Yeah. Okay. Mr. Iddings, let's take a copy of this just for his benefit. Maybe Noah wants to take it and kind of help him figure out how he's going to do this, but he can't blow it off like he has pretrial. He'll end up in jail. We're done. Okay. This last chance is really to give him the benefit of the circumstances. September 11th, in 2 weeks, we're going to come back at 4:30. September 11th at 4:30. Mr. Brown, you don't contact pretrial, you don't do your pretrial, I will rise to your challenge, you will go to jail. Do you understand? Okay. Why? Because DUI, vehicular eluding, driving under restraint, open container in the car, careless driving, resisting arrest, another DWAI, second degree attempt to assault a peace officer, resisting arrest, trespassing to someone's dwelling, resisting arrest again, obstructing the government, violating protection orders, and violating protection orders again. If you think I'm messing around with you, you will be sadly mistaken. Figure this out in the next 2 weeks. Or be prepared to go through those doors when you come back on September 11th. This is your last chance to get bond compliant. Thank you.
Yeah, that's what we call him too. Shit on shingles. Hold on, I'm trying, guys. I'm trying. There we go. I know. It just played for a second. So it was, I was just trying to get it set up. You know, it happens. Premature playing of videos happens to everybody at my age. You know, like you think everything is fine, and then, all right. It was just a second. Gosh. Okay. We did good. We didn't get to Eric Johnson because I liked this judge, so we stayed here. We stayed with the lady judges today. Only on this channel can you find these judges, just so you know. Yeah, I got the outro set up, so I'm going to play it. And then a lot of you will be popped over to OJ automatically. And by a lot of you, I mean like 4. But that's a lot. Trust me, it's a lot of people to watch a stream. You guys, I'm very famous. I get at least 4 people in my OJ streams. So you need to address me better than you normally do. Very famous. John the Beagle Dad knows me by name. Yep. Thanks for coming out. If you watched that video, I would appreciate it. It just drooped really bad last night, and I thought it was a really good one. So maybe if it gets a little boost, it'll... Who knows? Who knows? I'm going to OJ. I'm going to make some cream chick beef on toast and have a great morning. Bye, guys. Thank you. Now I can press play of it. I lost it though. Is that it? No. It was just playing, so I know that I have it. Oh no, is this it? This is it right here. Oh boy. Oh boy. Oh boy. I found it. But I don't want to be in it. I want to be gone. There we go. Bye, guys.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her street sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a wake, there's no alarm. Freedom feels late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a wake, there's no alarm.
wasn't supposed to happen right there. Right here. Thank goodness it's just OJ, not something worse.